now there, give your attendance, you shall be heard. Live tape in the Commonwealth of Massachusetts. This court is now open. You may be seated.
May I call the case, Your Honor?
Please.
This is 2282CR117, the Commonwealth versus Karen Reed. Mr. Lally?
Yes, Your Honor. The Commonwealth moves to trial.
Okay.
Ms. Reed, can you please stand? Karen Reed, you are now set at the bar to be tried, and these good men and women who I shall call to pass between the Commonwealth and you upon your trial. If you'd object to any of them, you must do so before they are sworn. You have a right to challenge any 16 jurors without giving reason. Thank you.
All right. So good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. My name's Beverly Cannoni. I'm a judge of this court, and I want to welcome you here this morning. Jury service, as you know, is one of the most important duties that we have as citizens. Our system of justice simply would not work without you, and we appreciate that you're here today, ready, willing, and able to serve if called upon to do so. So
You are unmuted.
we're selecting a jury today in a criminal case that you just heard, Commonwealth versus Karen Reed. The Commonwealth alleges that on the morning of January 29th, 2022, at approximately 6:04 a.m., the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road within their town. Officers responded and discovered the male party, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to his residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was later pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies that she has committed these or any crimes alleged in this case, and she has pled not guilty. So the defendant is charged, as you've heard, with second-degree murder and also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death. I will describe these crimes in detail at the end of the case when I teach the jury the law, but briefly, murder is the unlawful killing of a human being. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that in the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt and to a moral certainty. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask questions to you all as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the questionnaire and to my questions. I want to thank you in advance for the patience it will take as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you are not selected for jury service on this case, please don't take it personally. Don't think that somehow you're not a fair person. It's not a reflection on you at all. In a few minutes, I will pose questions to you as a group. You've taken an oath that requires you to truthfully answer these questions and all questions posed to you. If your answer is yes to any question, I will ask that you raise your hand and hold up your juror cards. No need to take those cards out yet. I'll tell you when I need you to take those cards out. When you hold the card up, please hold the numbers out because the court officers need to read the numbers from your card. The fact that you answer yes to one of my questions does not mean that you're automatically disqualified from jury service. It simply means that there are matters that counsel and I must discuss with you. If you find a question posed to the group overly intrusive, you may elect to answer that question at sidebar. I will have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding your ability to serve as a fair and impartial juror in this case. The lawyers are also permitted to ask you questions for the same purpose. Please remember, this is not a test. There is no right or wrong answer. We're simply looking for your honest and best answer to the questions. I'm now going to ask the lawyers to introduce themselves to you and to tell you who they represent.
Good morning, ladies and gentlemen. My name is Adam Lally. I'm Assistant District Attorney with the Norfolk County District Attorney's Office. I, along with my co-counsel here, represent the Commonwealth of Prosecution in this matter. Thank you very much for your attendance here.
Thank you, Mr.
My name is
Lally.
Laura McLaughlin. I'm also an Assistant District Attorney working alongside ADA Lally. Good morning.
All right, thank you, Mr. Lally and Ms. McLaughlin.
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Alan Jackson. I have the privilege of representing Ms. Karen Reed.
Good morning, ladies and gentlemen of the jury. My name is Elizabeth Little, and I'm also representing Ms. Reed.
And good morning, ladies and gentlemen. My name is David Yannetti. I'm an attorney with an office in Boston. Our client today is Karen Reed. If you'd stand, Karen. Say good morning. Thank you for being here today.
All right, thank you very much, counsel. Jurors, I have a very lengthy witness list to read to you. I'm going to ask that you pay close attention to it because in a little while I'm going to ask you if you know the names of any of these folks. Just because I read the names to you now does not mean that all of these people are going to be called as witnesses. In fact, they're probably not all going to be called as witnesses. There may be some reference made to them during the course of the trial. So it is important that we know whether in fact you know any of these people. And if you're not sure whether you do or not, when I ask you to raise your hand later about whether you know any witnesses, err on the side of telling us that you know them. Okay. All right, so yeah, at this point, Jim, why don't you do it now?
Could I have all the jurors please stand and raise your right hands? Do each of you solemnly swear to make true answers to such questions as should be put forth to you by the court, so help you God? You can have a seat.
All right, so the police witnesses, Trooper Michael Proctor from the Massachusetts State Police, Sergeant Yuri Buchanan, Massachusetts State Police, Trooper Zachary Clark, Massachusetts State Police, Trooper Connor Keefe, State Police, Trooper David DeChico, State Police, Trooper Christopher Moore, State Police, Trooper Matthew Dunn, State Police, Lieutenant Brian Tully, State Police, Trooper Nicholas Garino, State Police, Trooper Joseph Paul, State Police, Officer Stephen Seraph, Canton Police Department, Stephen Mullaney, Canton Police, Sergeant Sean Good, Canton Police, Sergeant Michael Lank, Canton Police, Lieutenant Paul Gallagher, Canton Police, Lieutenant Charles Ray, Canton Police, Lieutenant Kevin O'Hara, Massachusetts State Police, Officer Nicholas Barrows, Dayton Police Department, Sergeant Brian Gallerini, Needham Police Department, Trooper Evan Brent, Mass State Police, Trooper Everton DeCastro, Mass State Police, Trooper Justin Pye, Mass State Police, Captain Eric Benson, Mass State Police. I think I may have missed a police officer or two that I will get to before the end of the list. Heather Maxon from Plainville, Mass. Anthony Flamati from the Canton Fire Department. Dr. Irene Scordobello, the Office of the Chief Medical Examiner. Dr. Renee Stonebridge, also from the Office of the Chief Medical Examiner. Timothy Nuttall from the Canton Fire Department. Francis Walsh from the Canton Fire Department. Matthew Kelly, Canton Fire Department. Gregory Woodbury, Canton Fire Department. Katie McLaughlin, Canton Fire Department. Jason Becker, Canton Fire Department. Daniel Whitley, Canton Fire Department. Wendell Robery, Canton Fire Department. Jennifer McCabe from Canton. Matthew McCabe, Canton. Allison McCabe, Canton. Kerry Roberts, also from Canton. Kurt Roberts, also Canton. Paul O'Keefe from West Bridgewater. Erin O'Keefe from West Bridgewater. A juvenile with the initials KF from Canton, Mass. A juvenile with issues PF from Canton, Mass. Counsel, do you want me to say the relationship?
I don't think it's necessary.
I need more than KF.
Okay. Then yes.
Yeah. These two individuals are juveniles who are related to the deceased Mr. O'Keefe. Michael Camerano, Canton. Catherine Camerano, Canton. Brian Higgins from Sandwich. Brian Albert from Norwood. Nicole Albert, also Norwood. Brian Albert Jr., also Norwood. Ian Whiffen from Alberta, Canada. Dr. Justin Rice from the Good Samaritan Medical Center. Daisy Ormseth, who's a nurse practitioner at the Good Samaritan. Kathleen Wilfert, also a nurse at the Good Samaritan Medical Center. Dr. Gary Fowler, the medical director of Good Samaritan. Terry Kuhn, who is from the University of Davis Veterinary Lab. Nicholas Bradford, who is from Bodie Technology, and that's in Virginia. Tess Chart, also from Bodie. Julie Albert from Canton. Christopher Albert and Colin Albert, all from Canton. Ryan Nagel from Canton. Tristan Morris, who's from Easton, Mass. Caitlin Albert, also from Easton, Mass. Gretchen Voss from Boston. Louis Jutres from Canton. Nicholas Roberts, who is with the Massachusetts Office of Alcohol Testing. Sarah Levinson from Canton. Andre Porto, the Mass State Police Crime Lab. Ashley Valier, Mass State Police Crime Lab. Maureen Harnett, Mass State Police Crime Lab. Christina Hanley, also from the Crime Lab. Sophie Herzan, also from the Crime Lab. Brian Loughran, from Canton. Richard D'Antono from Canton. Jean DeMoulis from Canton. James Sullivan, also Canton. Stephen Bernstein from Stoughton. Juliana Nagel from Canton. Nicholas Kolokethis, I'm sorry for messing up that name, also from Canton. Michael Trotter from Canton. Rebecca Trayers from Canton. Bridget Meehan, Canton. Jessica Hyde from Bridgeport, New York. Marietta Sullivan from Pembroke, Karina Kolakithas from Canton, Laura Sullivan, also from Pembroke, Michael Wagner from Foxborough, Cheryl Waugh from Canton, Paul Mikowski from Melrose, Leslie Bernstein from Canton, Rebecca Bazin, also from Canton, Officer Paul Bowden from the Dighton Police Department, former Chief of Canton Police Department Kenneth Berkowitz, Trooper Evan Brent, Mass State Police, sorry, Laurie Cahill from Worcester, Christopher Curran from Canton, Kerry Curran, Canton, Nicholas Curran, West Roxbury, Officer Kelly Deaver from the Boston Police Department, Stephanie Devlin from the Mass State Police Crime Lab, Patrick Haggerty from Dighton, Lance Mello from the Mass State Police Crime Lab, Steve Nelson from the Norfolk County District Attorney's Office, Holly Price from Google, Trooper Kathleen Prince from the Massachusetts State Police, Elizabeth Proctor from Canton, Steve Ridge from the Boston Police Department, Heriberto Hernandez from the Boston Police Department, Mark Lopalato from Canton, Alfredo Lopalato, also from Canton, Angela Malvone from Canton, Courtney Proctor from Canton, Mary Souza from Dighton, Mass., Ashley Bell from Canton, Mike Rushworth from Thompson Station, Tennessee, Matthew Amory from Canton, District Attorney Michael Morrissey from Norfolk County, Thomas Beatty from Canton, Erin Beatty, also Canton, Megan Mariani from New York, New York, Thomas Martin from Weymouth, John O'Keefe Sr. from Braintree, Frank Sheridan, who is a forensic pathologist from San Bernardino, California, Chris Van E., who is a PhD in biomedical and mechanical engineering from Novi, Michigan, Richard Green from St. Petersburg, Florida, Daniel Wolf from Penn with an agency called ARCCA, Inc. from Penns Park, Pennsylvania. These other two gentlemen are also from the same place. Andrew Wenscheller, who's also a PhD, and Scott Klein, also from ARCCA. So those are potential witnesses in this case, or people's names who you will hear during the course of the trial. Now, this case is going to take, once we get a jury, anywhere from 6 to 8 weeks to try. The schedule that we can count on will be, we will go full days on Monday, Wednesday, and Friday, half days on Tuesdays and Thursdays. This is just a best estimate. Sometimes trials go longer, sometimes they go shorter. I'd rather tell you more time and have the trial be shorter than the other way around for your planning purposes. So it will go 6 to 8 weeks once we get a jury. Now, it might help you if I give you a preview on some of the basic law that applies to criminal cases like this. And as I've said, it's my job to teach the jury the law, and I'll do that completely at the end of the trial. So for now, I'll give you a brief summary of some of the legal principles that will govern this case. First, and most basically, the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. An indictment is merely a formal manner of accusing a person of a crime in order to bring her to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove his or her innocence, to produce any evidence whatsoever, or do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all of the evidence presented before you at trial. Another important principle of law is that the defendant has an absolute right not to testify. Since the entire burden of proof in this case is in the Commonwealth, to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the government, "You accuse me, now you prove it." I do not have to say a word. A defendant's decision whether or not to testify has nothing to do with the question of whether she is guilty or not guilty. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and exhibits. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that will be put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, a juror's job is to find the facts. In determining the facts, you may draw reasonable inferences from the evidence that you believe because you are entitled to rely upon both direct and circumstantial evidence. I will define those terms in greater detail later, but direct evidence essentially is evidence of what a person claims to have seen or heard or touched or somehow perceived with his or her own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Jurors are entitled to consider both kinds of evidence. There is no difference at all in the probative value between direct and circumstantial evidence. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, I've used the word inference. An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate or engage in surmise. When the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making your mind up before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you individually and as a group do your best to resolve this case based upon the evidence and the law without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you have heard the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything that I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all jurors have to apply the law as I describe it to you. So for jury selection, it's important to know if any of you might have some doubts about whether you can accept and follow these legal principles. Now I'm going to ask you those questions. So please take out your juror cards. And if your answer is yes to any of these questions, please raise your hand. And we'll have you, the court officers will call out your number. But before I begin, I understand that sometimes jurors do not fill out juror questionnaires completely. Sometimes we're in a rush to send them in, or sometimes we don't think that our situation applies to the question that's being asked on the confidential questionnaire. If the lawyers and I notice that the questionnaire appears to be incomplete, we may ask you to answer the question for us. Also, if you know now as you're sitting there that you failed to include information on the questionnaire, for example, a work history, prior involvement with the court, whether as a party in a case, a witness, or a juror, please make sure you let us know. All right, the first question, do any of you or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names I've read?